Welcome to the Nebraska Court Improvement Project 2024 Legislative Overview. I am Deb Van Dyke Reese, Director of the Nebraska Court Improvement Project. It is my pleasure to introduce this annual webinar and extend a heartfelt thank you to today's panelists, as well as Mary Pat Coe and Teresa Cusick for tracking legislation and preparing for today's webinar. I want to cover a few housekeeping items before we start. Questions for the panelists are welcome and can be posted in the Q&A at the bottom of your screen, and we anticipate having time at the end to answer those questions. The webinar is being recorded and will be housed on the CIP YouTube channel. CLEs have been approved, and that information will be shared at the end of the webinar. Tracy, next slide, please. The Nebraska Court Improvement Project is part of a nationwide network of court improvement programs focused on juvenile court processes and improving outcomes for children, youth, and families impacted by juvenile court. Nebraska CIP has 5 target areas for our work: education of court and stakeholders, collaboration, utilizing data to inform decisions, developing publications to increase understanding of the court system, and our Through the Eyes of the Child teams. So our Through the Eyes of the Child teams are judge-led multidisciplinary teams that focus on local items to improve court processes and outcomes for families. Judge Roger Heidemann and Judge Randon Rowland are the lead judges for the Through the Eyes of the Child initiative, and I appreciate their leadership on this initiative. If you'd like more information about the Through the Eyes of the Child teams and that particular initiative, you can find that on the CIP website in the link that is found below. So now I will turn it over to Mary Pat Coe to start our legislation.
Thanks, Deb. Okay. We're going to go through just how bills become laws real quick. Tracy, I don't have a fun little music thing on this slide. Can you help me out there?
No, I'm not seeing it.
Oh, well, dang. We had the little How a Bill Becomes a Law song, but I'm not going to sing it. So we'll try for next time. So as most of you know, we in Nebraska are unique. We have a unicameral. And in the first 10 days of the session, that is when bills are introduced, all the bills get a fiscal note, so that everybody knows basically the state, county, and city costs of any of the changes that a bill might have in it. Each bill is then referenced to a committee, and every bill gets a public hearing where individuals can testify for the bill, against the bill, or in a neutral capacity. After the hearing, the committee can vote to send the bill to general file with or without amendments. They can indefinitely postpone a bill, or they can take no action on the bill and just leave it in committee. The next step, a committee can send, as I said, the committee can send a bill to general file, and that is the first time for the full legislature has to debate on that bill. Any amendments can be added. In order to add an amendment, it takes 25 votes, and then it takes 25 to move the bill on to general file. I'm sorry, from general file to enrollment and review. And in that area, that incorporates any amendments and also checks for grammar. It goes on to select file, and this is a second chance for debate and voting. Again, there's an opportunity for amendments, and then again, voted forward. Or it can be amended or postponed. So again, if it gets voted forward, it goes on to enrollment and review. And again, that incorporates any amendments that were put on in select file or checks for grammar. The last area is final reading. During this, it may not be amended. However, it can get sent back to select file if a majority vote says so. Otherwise, it is moved on to the governor. The governor has 5 days to decide whether to sign the bill, line item veto, or veto it. In order to overcome a veto, the legislature has to have 30 votes. let's see. As you'll know, if you go through on the legislative pages, you'll see some bills are set as priorities. Each senator gets one priority bill, and each committee can have two, and the speaker can designate 25 bills as priority. This is our short session this year, and it ends on April 18th, unless the speaker decides otherwise. So that's kind of in a nutshell how a bill becomes a law in Nebraska. We are again so lucky today to have our panel of experts. We have Elizabeth Einen-Kokerda, who is a managing attorney of Education Rights Council. Sarah Helvey, who is a staff attorney and director of the Child Welfare Program at Nebraska Appleseed. Dennis Marks is a Sarpy County Deputy Public Defender. Bree McLartley, sorry, Bree, I have trouble with your last name, is a Sarpy County Deputy County Attorney. Carrie Rumbar is our Deputy Administrator for the AOCP. We have Judge Elise White, who is on the Lancaster County Separate Juvenile Court Bench, and Ashley Peters, who is Administrator of Policy and Legislative Services at HHS. So I know everybody's anxious to get started, and we're going to start off with Elizabeth, who is our expert on all things educational.
Thank you so much, Mary Pat. I'm not sure I'm going to go to expert on all things educational, but I love coming and talking about this. For those of you on the line that are not familiar with Education Rights Council, we are a nonprofit that works specifically to create systemic change to keep kids in school. So what we try to do is remove legal barriers. Where that comes into play in the juvenile system is that we accept limited representation education appointments in all three of the separate juvenile courts. So while what happens in all of the courts is sometimes there's an educational impact that's going to impact juveniles. I've been asked to talk about the bills that you see before you here today. I'm going to tell you a little bit about what they do, and then from my perspective, how it might impact your work with a student that's in the juvenile system. So the first bill is 1193, and it's introduced by Senator Conrad. And effectively what it would do is permit parents and guardians the right to have a child repeat one time under certain circumstances. What we have seen in the juvenile court sometimes is kids that have missed so much education. They have been out for either mental health reasons, sometimes educational neglect reasons. And from time to time, they are so far behind that a parent seeks or a guardian seeks to give them the opportunity to actually repeat a grade. And often it's not repeat the grade because they didn't do well. It's repeat a grade that they never had access to. And in Nebraska right now, the only entity that can decide whether an individual may repeat a grade is the school district. And most school districts have undertaken a stance that repeating a grade is not going to be allowed until you're in 12th grade. Often what happens at that point is children are so far behind that they give up. And so what we see sometimes at the higher education level, not higher ed like college, but I mean in 9-12s, is students that end up dropping out when they're 16 as soon as they can because they aren't really able to access their education because they've had too much difficulty and barrier. So what this bill would do is for younger kids, i.e. kindergarten through 4th grade, it would allow parents under certain limited circumstances to have a child repeat once. Those limited circumstances are academic neglect. Academically behind, I guess is what it would be. Academically behind or hospitalized for 2 or more weeks, or they've actually missed 50% or more of the school year. My understanding about why it's limited to 4th grade and less is because there is research that shows that when a child gets older, holding the child back can actually have some negative social and emotional consequences. So the bill permits the parents to do this, but only up through grade 4. It does have one other exception for older students. And at that exception would be a parent could hold a student back if the student missed 50% or more of the school year. So it wouldn't go just to be academically behind or, kids that are hospitalized for mental health reasons or others. It would specifically go to, I have missed more than half a year. That is, I think the goal of it is to just basically give some parental voice in this process. and to allow them in these limited circumstances to make that choice for their children. The impact I see is it may improve the ability of a child to exit the system because they could become more successful if they've missed. And we know that court orders are always seeking to have children attend every day and be successful in school. And we want to see them successful in school. So there is a component to this that could help students more quickly and successfully exit the system. Okay. Regarding LB 1141 by Senator McKinney, to me, this looks like a cleanup bill from last year, if you will, which is last year, Senator McKinney proposed and was passed into law a bill that they called Too Young to Suspend. And basically, it was for pre-kindergarten through second grade. Children were not to be suspended or expelled anymore. And the idea was that children who were that young, who were exhibiting behaviors, behavior is communication. And if children are exhibiting these behaviors, what we need to be doing is reaching out and, from a holistic perspective, trying to meet the needs of the child by providing additional supports and services. Anecdotally, what I understood or understand is happening is that some schools are using a different exception with regard to holding children out of schools. In addition to school discipline, there is the right to emergency exclude a child. Emergency exclusion exists for things like if I'm a child with lice, I need to maybe be excluded until I get that under control. If I am a child that is maybe dangerous, and we need to figure out whether the danger I have evidenced in the school setting can be ameliorated and maybe a plan can be put in place, I have the right as a school district to emergency exclude that child for up to 5 days. So what this bill does is say in the no gun, not in a gun setting, not in a super dangerous setting, but in the framework of not disciplining children, we're not going to emergency exclude them either. What we will do is keep them in school and try to create a behavioral support plan for them. And again, this pre-kindergarten through second grade. Unfortunately, what we see is the data is children at that age are being expelled and suspended almost as much as children in high school. This bill also has one other thing. It addresses the rights of parents to bring in action with regard to corporal punishment. The law prohibits corporal punishment in the schools. One of the concerns, as I understand it, is that children are being corporally punished by SROs or school resource officers who may engage in pain compliance, in part because that's what law enforcement is taught to do in order to get compliance. So these two things are in conflict. And what this bill would do, as I understand it, or what it attempts to do, is hold the school district accountable to ensure that we aren't having corporal punishment by creating a remedy. Right now, the only remedy the only remedy from the school district perspective might be, say, a state tort claims action. And I think, as we all know right now, that is pretty much not possible to do given the legislative language with regard to anything arising out of an employee's action is protected by the Tort Claims Act. So this would carve out, I think, a little piece of that. Okay, that's 141. I'm going to go very quickly with regard to LB 1146 and 1189. Those are basically in response to LB 1141 from last year. They're each a carve out. The 899 just basically says carve out all class 3 school districts, which is everybody except Lincoln Public Schools and Omaha Public Schools. So they're saying, this bill essentially says it's only the big schools that are expelling kids. The smaller school districts don't need to have this in place. I'm not sure that's what the evidence shows. So I'll be interested to see what the testimony is on LB 899. And then 1141 basically says, well, we're going to carve out any pre-kindergarten through second grader who is, quote, capable of causing physical harm to a student or an employee. So in other words, their actions, whatever they did, whatever behavior they evidenced, if it was possible that it could have caused physical harm, you can still expel them. Unfortunately, at least as I understand it, this goes directly to the heart of the matter, which is if we're having behaviors, it's communication. We need to be putting supports, not expelling just because a child threw a tantrum and kicked his feet, and had somebody been in the way, it could have hurt them. Again, this is all relating to PK through second grade. And lastly, I've been asked to talk about LB 1029. 1029, as I see it, essentially seeks to protect children and parents whose mental or physical health impedes their access to education from becoming part of the system. So it is the mandatory attendance requirement that says you must cause your children to attend, and otherwise, an action can be brought against you for truancy if your child is not attending school. This says we wouldn't consider absences due to mental or physical health a reason to bring an action in the juvenile courts. At least that's how I understand what it would be happening, because it basically just carves out mental or physical health as an absence that would count as a truancy. And I think that is all for me. And I loved going first for once. I got to talk about education. Thank you so much, Mary Pat.
You are very welcome. Thank you, Elizabeth. And we love having you go first. And depending on our time, we may kick some back to you at the end, because I know you had a couple more that were on your list that people.
We're not going to have time.
We'll just see. We'll let you know. All right. Our next expert up is Judge White from Lancaster County. Thanks, Judge.
Thank you, Mary Pat. I am Elise White. I am judge in the separate juvenile court of Lancaster County, Nebraska. I am the current chair of the Nebraska Juvenile Court Judges Association Legislative Committee. So I'm the one that the 12 juvenile court judges have tasked with keeping tabs on pending legislation for our association as well. I have 3 that I'm going to talk about, and one of these is you're going to get some more in-depth information later on. So I'm just going to briefly touch on that one. The first bill, LB 832, was introduced by Senator Blood. And what this looks to do is to basically fix an area of law where if we have a law violation that is occurring on federal military bases, as you may be familiar, the federal court system does not have a juvenile court. And so what LB 832 would be authorizing acceptance or cession or retrocession of federal jurisdiction for juvenile matters with regards to juveniles on military installations. And Nebraska would adopt concurrent jurisdiction policies to ensure access to state resources for juvenile courts and appropriate adjudication options to respond to any needs for any juveniles that are adjudicated for any offenses that were alleged to have committed on federal military land. This just kind of the nuts and bolts would allow the governor to execute an executive order on behalf of the state for full, partial cession or retrocession of federal jurisdiction, so that juvenile courts could handle any issues that would arise that would be under the juvenile court's jurisdiction that would occur on federal military bases. So I think this is mostly going to be looking at affecting our friends in Sarpy County. LB 911, again, introduced by Senator Blood. And I'm just going to briefly touch on this one because I believe you'll get a more in-depth look at this one later on in this presentation. This is related to the Nebraska Indian Child Welfare Act to amend Section 43-1501 to provide specific duties for the Department of Health and Human Services and Office of Probation Administration relating to cases that would fall under NICWA, and add some things to that, and then harmonizes some provisions of that statute as well. So I will, let our presenter, Ms. Helvey, is, I think, going to go into a little bit more depth on that one. Last one I've been asked to speak on today is LB 890, which is introduced by Senator Bozen. And this amends Section 43-2108.05 to provide for certified copies of sealed juvenile records to attorneys in specific matters. So what this would do is, upon request, the clerk of the court would provide certified copies of sealed juvenile records to any county attorney, city attorney, or attorney representing juvenile whose record has been sealed for purposes of being offered. And this is specifically for hearings on motion to transfer case to or from juvenile court or district court under 29-18-16 or 43-274, or with regards to the prosecution of any such offense. So this would modify the current legislation to allow for those specific records to be unsealed and provided to those specific attorneys in that venue.
Thank you, Judge White, and thanks for being here this year. We appreciate having you.
Thank
All
you
right.
for letting me.
Next up is Bree from the Sarpy County Attorney's Office.
And unmute myself. Okay, well, this is perfect because the first one on my list was LB 890, the sealed records. So to give a little context to this bill, this was actually brought to Senator Bosman by the County Attorneys Association. What we've been seeing is there was a difference of interpretation from county clerks across the state about how and if they can even provide certified copies of the sealed juvenile records. And we were seeing this come up a lot in those motion for transfers on both sides, going from juvenile to adult, but also for defense attorneys that were asking to go from an adult to a juvenile. So for example, in that situation, if a defense attorney wanted to prove, hey, this kid had a previous case, but they only had, IOP, or, they only had an appropriate decision-making class, they were never able to avail themselves of some of our more intense community-based services like multi-systemic therapy or cognitive behavioral groups. So there's still more that can be done. They weren't able to get copies of those sealed records that showed what the probation order was saying. Yeah, they only had this one part. They didn't have all these other services. So kind of works both ways. Obviously, it's pretty obvious why the county attorneys would want that information. But we're just seeing that this information that in statute was already available to these attorneys. There was no formal process that the clerks could follow where they felt comfortable saying, yes, I will get you the certified copy. So we're not changing who has access to it. We're just changing or making it clear that these are things that can be provided, and then giving a statutory basis on which the clerks can rely on in doing that. So that's one of the things that we were supporting in LB 890. Now, LB 595, this is the transfer case where I think a couple of years ago, we had the law change that the judges had to issue an order within 30 days because we were having judges sitting on these transfer hearings for months. So the 30 days is already in statute. This creates an automatic transfer to the juvenile court. The county attorneys are having a problem with this because this really is kind of a separation of powers. There's a huge factor test that we have in statute in 43-276 about everything that the court needs to look at when making that decision about whether to keep it in adult court or transfer to juvenile or vice versa. Some of those include, the violence that was alleged, prior services that the juvenile has participated in, available treatments. So there's just a lot of factors that go into it. This is why we ask the court to weigh these factors when making the decision. So having that automatic transfer really has a huge impact when we don't have an order that reflects the factors that they're supposed to be looking at, because there is a huge difference in what's available in adult and juvenile court, not just in services that are available, but also placements that are available. If we're talking about a juvenile that has a violent crime, we're now talking about an automatic transfer to juvenile court that completely changes on what grounds we can detain a child, what evidence we have to put into place, and what placements are available. So for us, that kind of automatic, while I understand the frustration of not getting that order within 30 days, I don't think the appropriate remedy is kind of dumping the kid in juvenile court and hoping for the best. So that's a concern we have with LB 959, and I just don't know if the solution Senator Duggan is thinking about is really going to work out very well. So going now to LB 963, there are some states that do it this way. I know, for example, in Missouri, the Public Defender's Office is actually organized this way where it's a statewide approach, and then you're assigned to an office with a state branch that's kind of overseeing all of it. With LB 963, the two kind of things I want to point out is one of the benefits of having county attorneys is you have that local control and accountability, where you are really reflective and responsive to those in your community. You're there. I think for every county attorney that's elected in the larger counties, you physically have to be a resident of that county. We obviously make some accommodations for some of those less populated counties. So that is a benefit. Some counties even require deputies to be physically living in that county. The other thing that I don't think Senator Wayne really thought through on this one is with the separation of powers. When I look at wanting to appeal something or making a decision about how I'm going to handle a case, my kind of higher up is Lee. He's my boss. That's kind of where it stops with us. With HHS, they kind of go up a chain of command. And when you see HHS legal attorneys sign off on motions or things like that they're filing in juvenile court, it's under the AG's auspice. So now we're talking about the AG would have not only control and kind of the final say on some of the HHS decisions about whether or not to appeal or whatever you'll see in a 3A case, but you now have county attorneys that have to answer to the AG's office. And sometimes I don't agree with the department about how something is being handled or what they're recommending. So now you're putting me in a situation where I'm now opposing someone and disagreeing, but we have the same kind of powers that be. So I don't know if I think that was maybe an unintended consequence, but something that's kind of just to flag about. Some things may sound good on paper, but when you really dig through about how the juvenile court actually works, we might be making conflicts when there weren't any before. Now going into LB 1208, this is by Senator Bosden, and this is kind of almost reverting back to how the detention statutes used to be before the most recent law change, which really narrowed it to only failure to appear or danger to the community. I understand that this actually came from Senator Bosden speaking closely with Lancaster County Attorney's Office, because we are seeing a lot of kids where they are in crisis. And something to remember about the statutes is they have a ripple effect. So when we made that statutory change, that then changed the risk assessment index that probation uses and how they score kids and how they're recommended for either detention or alternatives to detention. That then changed how law enforcement decided whether or not to call out juvenile probation, because if kids weren't be scoring high enough to be detained or those intervention services, then law enforcement was less likely to call because why would we call? Nothing's going to happen. And so with that, we now have kids that are in crisis, but since law enforcement isn't going to call probation to do an intake, we're not getting that scoring assessment to have intervention services like crisis stabilization. So placement at places like Cedars, Boys Town, CSI. And so we have kids that are in crisis. They're not necessarily rising to that level of danger to the community. They're not breaking into cars. They're not causing significant property damage, but they are engaging in problematic behaviors, usually ones that are related to drugs or alcohol that can put them in danger. But we're not now having that intervention where we can offer parent services. I don't know if this is necessarily the best approach, but I think all of us that are working in juvenile court are seeing these kids either they come into our court and they're really spiraling, and we look back and realize there were points where there could have been interventions, but the avenues weren't there. So that's something I always struggle with, because you don't want to put kids in detention if you don't have to. But when you're sitting across the table from a kid that's having one of those crises, you're kind of grappling at what can I do? What can I provide? How can I help? So I'd say I'm neutral on this. I know the county attorneys are supporting it. I think this is just a bigger problem, and this is maybe one possible part of the solution, a bigger solution. But that's just some context about some of the stuff we're seeing. Also, when you're looking at the detention statutes, they really are clear about detention. But now we've created this subsect of alternatives to detention. I know Dennis and another attorney in my office just recently went to the Supreme Court about this, about detention versus alternative detention. And we've kind of created this weird subsect that is quasi involved in statute, but really more just a creation of the alternative. So I think that's something we are going to have to start looking at long term is what are alternatives to detention or crisis stabilization? How can we incorporate those in statute to allow for their use, but also allow for the use without maybe full-on intervention in the juvenile court system. So it's just kind of a rambling thought about detention and some of the bills we have in the legislature right now that's proposed. LB 1222, this was introduced by Senator Day. This is a really weird quirk we found in the termination statutes. So in a 3A case or a child abuse neglect case, you have your first adjudication. And then after trying to implement a rehabilitation plan, if that's what's appropriate, you then have the basis upon which you can terminate a parent's parental rights. And there's, I think, about 10 or 11 of them. And there's one specifically about sexual assault of the other parent. But in looking at the cross sections there, it's limited to the statutes where it cross references are to sexual assault of a child. So 28.319.01 is first degree sexual assault. So you're talking about penetration where the minor child is less than, I think, let me do the numbers, less than 12, and the perpetrator is older than 19, or they're less than 14 and the perpetrator is older than 25. And then that's the second and third degree assault. So you're saying that you can terminate the parental rights of the offending parent, the perpetrator, if the victim is essentially a child parent. So they're either under the age of 14 or 12. I've had a few cases recently where the sexual assault is on an adult parent, and the relationship and that co-parenting is so toxic because some of that did occur either in the presence of the child or the child was very aware that it was happening. So it's not saying you have to terminate. It's saying that in that situation where one, there's been a first degree sexual assault of the parent by the other parent, and it's not in the best interest of the child to have that parent's rights remain intact, then the state could look at terminating that parent's rights. It's not a de facto, it's not an automatic. It's just, I think, expanding the statute to what maybe they intended was to, if that situation, we were to find ourselves in that situation, that is an option we can have. But obviously we always have to look back to that. Is this in the best interest of the child? And that is a very fact specific inquiry that the county attorney would have to look at before filing, and obviously would have to look at putting on at any termination proceeding. And then finally, LB 1331, there are a lot of truancy bills this year. We could talk about them probably this entire panel if we wanted to, but I just wanted to flag this, as I've heard some other counties are starting to look at doing this, is this one would create the compulsory education law, class 3 misdemeanor. And just something I want to flag, we didn't take a position from the county attorneys, we're monitoring it. I would say this is getting into some really dangerous territory, because you're talking about a class 3 misdemeanor on the parent. And in theory, you'd think, oh, well, we could bring them together in juvenile court. But the juvenile court is a court of special jurisdiction, and it's very clear who we would have jurisdiction over. And it's very clear that when you have jurisdiction over a parent, it's only in the situations of establishing, paternity, guardianships, or a 3A case. So you're looking at charging this parent criminally with a class 3 misdemeanor in county court, not in juvenile court. There's no guarantee that those are going to be connected, that they're going to be coordinating, that the services that are offered through adult probation or adult diversion are going to be capable of identifying what services the family might need as a whole to address that excessive absenteeism. I think he's just trying to hold the parents accountable, because sometimes I think the parents are part of the issue about why we're seeing these truancy issues or excessive absenteeism. But having them be charged criminally, I don't know if that's going to yield the results we want. For people that don't know, the punishment for a class 3 misdemeanor in adult court is either up to a maximum of 3 months in jail, a $500 fine, or both. I don't see how a fine is going to have the intervention and the services that the family would need to develop the habits to improve attendance consistently. It kind of just feels like we're trying to scare the parents into complying. And I don't see that as a good use of court resources, especially when you're talking about it being in 2 separate courts and they're not able to really communicate and talk to each other. At least it really depends on the county attorneys and the defense attorneys working together. So that's just one that not a big fan of. And I think it's maybe going to create some more problems and not a lot of solutions. So I wish I had a good one to end on that's like positive, but there we are.
Thanks, Bree. All right, next up on our panel is Sarah Hilvey from Appleseed.
Hey, hi everyone. I want to start by thanking Court Improvement Project for inviting me to present today and just mention a few priorities of Appleseed for the session. The first bill I want to mention is LB 945, and that was introduced by Senator Jana Hughes from Seward. And this bill seeks to address access to vital documents for young people who exit care. And it really is based on feedback from young people who shared that they are missing access to some of the vital documents necessary to obtain a job or enroll in post-secondary education. And then also on an emotional level, young people share that they lack some of the deeper knowledge of their own childhood. So many don't have any photographs from their childhood and their growing up years. They're still missing they don't have the addresses, or the names of where they went to school if they moved around. And many of them don't have really an understanding of why they were in foster care in the first place. And so existing federal law, the Preventing Sex Trafficking and Strengthening Families Act in 2014, already requires states to provide young people with their birth certificate, social security card, health insurance information, medical records, and a driver's license or state ID when they age out of foster care. And then Nebraska law expanded on this to include additional documents and information. However, in the 7 years since the state law was passed and implemented, young people have said that they're not always getting those documents and identified additional gaps in access to information. And so LB 945 seeks to address those by requiring DHS to provide the following additional items: foster care reviewed office reports, case numbers and court records for the child, available photographs, and a written explanation of the reason the child came into foster care. And then the bill also clarifies that medical records, which are already required to be provided under existing state and federal law, as I mentioned, just clarifying that that includes documents related to psychological care or evaluations, as well as a list of providers the child saw in care. And then the bill also specifies that educational records, which already are required to be provided, include award certificate and grade reports. Again, these are things that young people say they desire. And in some cases need as well in terms of applying to college and other things. In addition, the bill permits the child or their GAL to request that the child be given access to other documents that are important to them that are not on the required list, that just may come up on a case-by-case basis, but requires a juvenile court to make a determination that such access is in the child's best interest. And then if any party objects, the bill allows the court to redact information or take other measures to address privacy or other concerns of the objecting party or the court. And then if the court grants the request, the bill also directs DHS to provide them within 30 days of the order. The bill was referenced to the Judiciary Committee and had a hearing last week on Wednesday. There was a lot of support. We're currently working on an amendment with Senator Hughes to address some issues raised by HHS and the committee, but we're hopeful that it will move forward. The next bill I'm going to mention, following up on what Judge White shared, is LB 911, introduced by Senator Carol Blood. The intention of this bill is really to get better data around ICWA compliance in Nebraska. So specifically, it requires HHS to ensure records are kept that allow for the analysis of ICWA data, including whether the child is, some of the basics of ICWA, whether the child is an Indian child under ICWA, whether the child is a member of or eligible for membership in or affiliated with an Indian tribe, whether ICWA applies to the case, and if so, the date DHHS was notified by the tribe that ICWA applies, or the date when the return receipt was received of the notice, whether qualified expert witness testimony was provided, and some details about the witnesses and testimony, whether the tribe intervened in the case, whether the case was transferred to the tribe, the active efforts made, and the child's placement according to ICWA placement preferences. And then importantly, the bill then requires HHS to provide a report of de-identified data to the Commission on Indian Affairs. And I think that's sort of a key part of the bill. The bill was referenced to the Judiciary Committee and has not been yet scheduled for a hearing. Just making sure that's what you have on the slide too. Correct. Okay. And then the last one I want to mention is LB 1417. And this was introduced by Senator Tom Brewer at the request of the governor. It is a 101-page bill, but what I think is relevant to this group today is that it would terminate several committees under the Nebraska Children's Commission, including the Alternative Response Advisory Committee, the B2I Advisory Committee. I happen to sit on both of those, the Children's Behavioral Health Task Force, and the Foster Care Reimbursement Rates Committee. It terminates all of those. And we think that those groups continue to play a very critical oversight role. They were created, as many of you remember, to address specific issues and crises within the system, and their ongoing role we think is really important. Also, the bill would put the Foster Care Reform Office Advisory Committee, which is the governing board of the FCRO, and the FCRO Executive Director under the authority of the Children's Commission. And so while we think both the Nebraska Children's Commission and the FCRO are great, we don't think it's appropriate for the FCRO, which is an independent state agency, to be placed under the Children's Commission. And we're concerned this could take away some of the independence of the FCRO and their ability to continue to provide independent oversight of the foster care system. So we'll be opposing this bill. It was referenced to the Government, Military, and Veteran Affairs Committee, and it has not yet been set for hearing. And with that, I can turn it over to the next presenter. It looks like there's maybe a question. I can take a look at it and try to reply in the chat if that's the best way to do it. Mary Pat.
Yeah, otherwise, we'll compile all the questions and we'll ask them at the end just to make sure we allow for time for everybody to present.
Okay.
Thanks, Sarah.
Thanks, everyone.
One thing I wanted to quick point out, when Bree was talking about LB 1331, that hearing is this afternoon if anybody's interested, and it's in the Education Committee. And next up, and thank you so much, Sarah, for your expertise. Oh, I always like it when you can tell me that you're working on amendments with a senator. It feels like we're in the know. Next up is Dennis Marks from Sarpy Public Defender's Office.
Thanks, Mary Pat. Again, my name is Dennis Marks. I'm with the Public Defender's Office. And I've been tasked to talk about roughly 6 bills. And I'll get started with LB 1281, which deals with juvenile detention and alternative to detentions, because there's some changes made to that statute, which I don't think it's used all that much anyway, at least in Sarpy County. I can't speak for the rest of the state. So the way 43-255 reads now is that, you know, if you have a juvenile in detention, they're to be released unconditionally unless within 48 hours a juvenile petition's been filed, a motion to revoke's been filed, or a criminal complaint in county court's been filed. And I'll give you an example, a real life example, so that you can kind of picture how that works. So I had 3 Douglas County kids charged with, well, they weren't charged. They were detained on a Monday evening involving a stolen firearm that was not recovered. Detention hearing scheduled Tuesday morning at 11. That morning, county attorney decided to file adult. Youth continued to be detained, no detention hearing. The affidavit of warrantless arrest was forwarded to the county court judge who was doing bonds. And she got that actually at the bond hearings on Thursday. And subsequent to those bond hearings, when she read the probable cause affidavits, found no probable cause existed. Kids continued to remain detained, and then they scheduled a detention hearing Friday morning at 11. And at 9, I showed up in the judge's chambers with a motion and order releasing them pursuant to the language in that statute, because nothing had been filed within those 48 hours. So the way the bill is proposed is it really obliterates that 48-hour requirement and just says that, you know, if at any point the youth are detained, then the county attorney can file a juvenile petition, a motion to revoke, or they can file a criminal complaint. So in that situation, we would have gone ahead and had a hearing that Friday morning in that situation. The other change is hearings are actually required. And where that plays a relevant part is this bill is also extending to alternatives to detention. So Another real life example of how I think this bill is to the detriment of youth is from a public defender defense standpoint. That a youth gets detained. A youth has a detention intake after they find an unloaded handgun in his bedroom. Ray is done. Youth scores a 3 on the Ray, and detention releases him home on an alternative to detention. What we did in that situation was we stipulated to the continuation of the alternative to detention because we were afraid that to have a hearing could have resulted in detention. So we didn't want to take that chance, and my client felt like he could live with the alternative to detention, which was electronic monitoring. This bill eliminates the ability to do that stipulation. You're going to have a hearing in those situations. So the next bill is LB 1089, and that deals with exemption for costs and fees for juveniles. Before I get into that, I want to give a shout out. There's a group that's working on this and has been working on this. I'm not a part of that group. I'm aware of it. I know what they're doing, and it's the Nebraska Fines and Fees Coalition. There's a lot of stakeholders, some of whom are on this panel, again, not me, and some of who are the participants in the audience, and they have been working hard to work on this bill. And I just want to give them a shout out for the hard work that they've done on this, because what this does is it applies to juveniles in juvenile court. If you're under the court's jurisdiction for a misdemeanor, a felony, or a status offense. It also extends protection to juveniles in adult court who are less than 19 years of age. It also eliminates the payment of requirement to pay certain costs and fees. Now, there's an exclusion for traffic offenses and there's an exclusion for infractions. So the infractions are basically the possession charges, whether it's possession of marijuana or drug paraphernalia. But some of the costs and fees that juveniles may not be required to pay are probation fees, programming fees, docketing, filing fees. I think that pretty much applies to appeals and appeal bonds. I want to emphasize that this bill is not applicable to bonds. If you're on the adult side and you're required to pay a bond, or even on the juvenile side and required to pay a bond, that's not impacted by this. I think the winners in this bill are basically juveniles who are in juvenile court and their parents and guardians, or juveniles even in adult court, because juveniles in juvenile court are going to get probation whether they want it or not, whether they think they need it or not. But juveniles who are on the adult side, or the 18-year-olds who are, emerging adults, a judge has to determine whether or not they're a suitable candidate for probation. And some of those considerations, at least one of those considerations, is finances, because probation in adult court is not free, not like in juvenile court. So you have programming fees, probation fees that can add up if you've got someone who's going to be on probation for 12 to 24 months. And this would eliminate having to pay those fees for those 18-year-olds or younger, so that's one less consideration an adult court judge would have to consider in determining whether or not that particular youth was a suitable candidate for probation. Not sure what this does for when you're doing an appeal and you're having to fill out the informa pauperis application, affidavit, order, statement of finances. But it would seem to infer that they don't have to pay those things. So I guess the other winner in that situation might be the practitioner secretary who doesn't have to do that work. 1208. I think Bree did a really nice job of talking about this bill from a county attorney perspective. I think I'm in the minority on this because I think the general consensus is this is a good thing, that it's better to keep kids safe. And if that means detaining them, then that's what needs to happen. So if we step back in time, prior to July 2019, youth were able to be detained if for their own protection or even the protection of other people's property. This brings back being able to detain a youth for their own protection, because right now, youth can only be detained if they've got a demonstrable record of willful failure to appear at a scheduled hearing within the last 12 months, or if that youth constitutes a serious physical safety threat to the community. This would give a third basis to secure a youth. And I don't care for it because I don't necessarily agree with the fact that we're keeping the youth safe in detention. They can still self-harm. Got a couple clients that have done that, in detention. These are youth that are generally have some mental health issues, some extremely severe, that are in detention awaiting placement at PRTFs and detention facilities. Detention serves a purpose for our youth and for our community and juvenile court. And there's no argument with that whatsoever. It's just, what youth do you want detained is the big question. And I think youth who have severe mental health problems shouldn't be in detention. And I could be wrong on this, but I don't think the detention youth have had, all the necessary mental health training to deal with these type of youth. The emotions and trauma that these kids, go through as a result of being in detention. I don't think detention is the right place. We know detention isn't treatment, and we know detention isn't rehabilitative, although those are two conditions that are also being removed from this particular bill. Detention does adversely impact the natural progression of adolescent development with our youth. And if you look at the research and the studies, and this is what JDI is all about, Juvenile Detention Alternative Initiative, detention can also lead to increased recidivism and involvement deeper into the juvenile court system. I'm not sure that we want youth who have severe mental health issues mixed up with youth who might constitute a physical safety threat to the community. And part of my problem is we already have a mechanism. We have mechanisms in place to handle these situations. And you don't have to look any farther than Section 43-248-2, which indicates if a juvenile is seriously endangered by his or her surroundings, an immediate removal is necessary. Law enforcement can contact HHS, not JPO, not probation. And then you look at the next subsection under 248, it's subsection 3, and it allows the law enforcement to take a juvenile into custody. They believe that juvenile is mentally ill or dangerous. And that definition is contained, mentally ill and dangerous, in section 71-908. And it involves youth who may constitute a substantial risk of serious harm to themselves within the near future. It can include recent attempts of suicide, threats of suicide, or attempts at serious bodily harm. So I think HHS is the appropriate agency to contact. I don't think doing a detention intake is really the appropriate way to handle it. When they're placed with Health and Human Services, they can be taken to a mental health facility for evaluation and treatment purposes. So, okay, I'm going to get off my soapbox and talk about 1208. Or 1085. 1085 talks about eliminating guidelines for establishing new separate juvenile courts. So if your county has more than 75,000 inhabitants, you're entitled to a separate juvenile court. And we have 3 counties, obviously, where that's happening: Lancaster, Douglas, and Sarpy. And then when you look at the statute, it talks about if you have a population of 75,000 to 200,000, you can get up to 2 judges. 200 to 400,000, you get up to 4 judges. That's Lancaster. And then 400,000, 800,000, that's Douglas County. I'm not quite sure why this bill came out when it did, but I suspect it's because I think it's targeted at Sarpy, and to a certain degree, Hall County, because this bill will cap the number of judges at those numbers, regardless of population. And Sarpy County is, I think, the number 1 county in the state for growth population, or pretty close to it. Because right now we have roughly 192,000 people in Sarpy County. And by 2025, it's estimated we're going to cross that 200,000 mark, in which case that's going to trigger the possibility of another judge. I think Hall County's at roughly 62, 65,000. I think they're projected to hit 75,000 sometime in the next decade, and probably even less than that. So this bill is really aimed at reducing the number of judges available in juvenile court. And I'll tell you, we're not at 200,000, but we could use a 3rd judge. Our two judges right now work extremely hard during business and non-business hours. The calendar is just crazy, Monday through Friday. And, I think Sarpy County could use another judge to help with this caseload. The numbers aren't going down, they're going up. LB 959. And again, I think Bree did a nice job talking about this as well. As Bree said, right now the statute requires a decision within 30 days, but there's no teeth to it. There's no remedy to it if 3 months from now a decision still hasn't been rendered. I think this bill does a nice job of saying, hey, fish or cut bait, make a decision. As an aside, I've been doing adult court transfers to juvenile court for about 12 years. I've never run into that problem in Sarpy County, that we generally get those decisions out within 30 days, but I don't know what it's like statewide. And then 1057. 1057 creates 2 sections, one section to 291816 and one to 43274, subsection 5. And basically what it says is, a youth is entitled to file a motion to transfer based on that youth's age at the time of the offense. And not only that, but when a court considers whether or not to transfer a youth under 291816(2), subsection 2, to juvenile court, when the youth is charged, when the motion to transfer is filed, the time the motion to transfer is heard, or when the decision for the motion to transfer is rendered, shouldn't prevent a transfer from adult to juvenile court. I know that prevention language is in there, but all of those are still realistic factors that a judge has to consider in deciding whether to transfer it. So that language can be in there, but for me, the value of this bill is locking it in at when the youth allegedly committed the offense. And then it adds a similar language, identical language under 43274, subsection 5, when you're going from juvenile court to adult court, that it's, when the youth is charged or the motion to transfer is filed, when the hearing's held, when the decision is made, shouldn't prevent a juvenile judge from retaining the case in juvenile court. But as before, I think the value of the bill is it locks it in when the offense is committed. So, and with that, I'll pass to the next speaker.
Thank you so much, Dennis. We appreciate all of your asides on there to help us learn about the bill. Our next presenter, and just as a reminder to everyone, remember we lengthened our webinar to 1.5 hours so that we didn't have to cut anybody short and we could really give you a wealth of knowledge about all the bills that impact child welfare and juvenile justice. So our next speaker is Carrie Rumpaugh from Probation.
Good afternoon, everyone. Like Mary Pat said, my name is Carrie Rumpaugh. I'm the Deputy Administrator with the Administrative Office of the Courts and Probation Juvenile Services Division. I have 3 bills. One of them we've talked about a couple times, so I probably won't spend much time on that one. But I have 3 bills that I wanted to share some information with all of you about. The first one is LB 921. This is a bill introduced by McKinney. This is a very specific probation and parole bill. So I thought that it was important that I share this information with all of you. What this bill does is it establishes an expectation for probation and parole to first create mentorship programming through educating probation and parole officers. So specifically speaking, on the probation side, there would be specific training expectations. Some of these include educational, vocational, service skills. There's also restorative justice mentioned in the bill, and it would really enhance the way that probation staff are trained. Probation staff receive a lot of training, and a lot of the items that they are talking about in the bill, probation officers do receive training on those items already. And then there would be probably a few additional items that probation officers would be added to for this really mentorship focused curriculum. The second piece of the bill talks about a mentorship program, and that individuals on probation, and this is adults and youth that are on probation, could participate in this program. The program in the bill talks about it being voluntary, but it also talks about there being specific criteria for who may be eligible for the program. The bill then goes into speaking about really regularly gathering data on already established and identified program outcomes and objectives. So there'll be some specifically identified program outcomes and objectives. And it also importance of the mentorship program being supported by community organizations, mental health professionals, and reentry service providers. So there's some clarity around engaging providers within the programming. This then moves into identifying some of the very specific evaluation criteria and reporting criteria. Not only, like I talked about, the data analysis piece, but it also speaks about more of a qualitative client feedback as well as officer feedback. So that would be your probation and parole officers, also digging into case management reviews. And they are also talking in the bill about creating comparison groups. So those that are eligible for the program and voluntarily participate, and those that are eligible and don't, or vice versa, those that aren't eligible. So really looking at those comparison groups to get analysis of that, as well as the cost benefit. And then it goes into more long-term goals and quality assurance of the program, ultimately requesting stakeholder feedback as well through the process. There's expectations for regular reporting and continuous improvement of the program. So really a strong focus on mentorship training, as well as the mentorship skills that a probation and parole officer can offer to someone that they're supervising on probation. So that's LB 921, and you'll see here it was referred to the Judiciary Committee. Like I talked about before, Senator Bozen introduced 1208. Appreciate the comments that Dennis was able to share. It really is important to look at what we know that data suggests around placing young people in detention and the importance of ensuring that detention is used for specific reasons due to just the way that detention centers are organized, which is a position where liberties are removed when a young person is placed in a detention facility. So we have some of the similar cautions for this, as it was something that was removed from legislation in the past, and do believe that it would be a pretty significant impact in regards to probation intake. And you'll see that one was referred to the Judiciary Committee as well. And then the final bill that I wanted to talk with you about today is LB 1282. This is a bill introduced by McDonald. This bill would create a youth renewal center for high-risk youth. They're specifically creating this youth renewal center under the detention facility piece of the law. So this would fall more into a detention facility structure by doing that within the statute. The Youth Renewal Center, as written in the statute, speaks to a specialized, secure environment and does speak to the importance of intensive treatment for severe behavioral health, mental health, and substance use concerns. It also identifies that there needs to be an intensive therapeutic approach within the facility and really looking at this comprehensive approach for youth that are very high risk. There are some specific expectations for the center. It includes the ability to have some analysis, again, performing evaluations by those that they're creating treatment plans for that would be at the Youth Renewal Center. There also is the expectation these centers can provide therapeutic interventions, including cognitive behavioral therapies, family therapies, group therapies, and trauma-informed care. There are educational programs that are required, as well as life skill training and substance use treatment that would be provided within these centers. There also is a statement about the essential need to also include recreational and culture activities and a significant focus on aftercare and integration back into the community. One item I wanted to bring to your attention is that these youth renewal centers could be operated by state, local government, or private rehabilitation or private entities for the rehabilitation for high-risk juveniles. And so that would be a new service or detention placement option within that bill. And Mary Pat, those were the three bills I had to share.
Great. Thank you so much, Carrie.
Thanks.
And our next and last presenter is Ashley Peters from HHS.
All right. Thank you, Mary Pat. My name is Ashley Peters, and I'm the Policy and Legislative Services Administrator for the department. The first bill that I am going to talk about is LB 876. This bill creates the Newborn Safe Haven Act, which provides added protections for infants by allowing additional avenues to surrender physical custody without any criminal liability. The approved drop-off locations for this bill are expanded to include licensed hospitals, staffed fire stations, and staffed law enforcement agencies, but they must display a decal or placard as described in the bill. The newborn in this bill can also be surrendered by calling 911. Additionally, this bill would allow for the use of newborn safety devices, which are also commonly referred to as baby boxes. The bill expands the age for the newborn to be 90 days old or younger, whereas current law is 30 days old or younger. And last, 876 would appropriate funds to the department to award grants for the installation of the baby boxes, as well as a public information program. This one, the status of LB 876 is that it was referred to judiciary. The next one I am going to talk about is LB 927. LB 927 requires the department to establish standardized suicide awareness training requirements for all employees of child placing agencies. And at least 90 minutes of training would be required for child welfare caseworkers and any other personnel as determined by the department. This bill also requires that the training must be completed prior to any independent contact with youth or families. And the status of this bill is that it was referred to HHS. The last bill on the list, LB 945, I believe a prior presenter has already gone over this one. I don't have anything additional to add to 945, but the hearing was held for this one on January 24th. And with that, Mary Pat, I will turn it back over to you so we have time for questions.
Great. Thank you, Ashley. I think a lot of them have been answered. However, as to LB 945, Rebecca would like to know, would this allow for adopted or guardianship children to have the same access for documents?
Yes, this is Sarah. That is the intention, is to include both young people who are adopted or guardianshipped. Language is young people who exit foster care.
Wonderful. Thank you, Sarah. And I think this goes to the Newborn Safe Haven Act. So Ashley, I don't know if you know this. Somebody wants to know how many states go up to 90 days for an infant.
Yes, Mary Pat, we did do some research on a lot of other states, but unfortunately, I don't have that specific information available right now. I don't know if anyone else would.
Well, if they do, they can give me a shout out. The other question we have still outstanding is on LB 876. I'll give whoever talked about that time to grab their notes. But what happens with paternity concerns while allowing anonymous surrenders? Oh, Ashley, you're up again.
Yes, Mary Pat, I just wanted to get to the right section of the bill. This is regarding anonymous surrenders. There is information. I just have to find what page it's on. But I do know there is information that like it's an assumed, I just want to find the right language, shall be a rebuttable presumption that the person who surrenders physical custody pursuant to this section is the newborn's parent or has physical custody or has the parent's authorization. So that's some of the language that is added in 876.
Great. Thank you for checking that out, Ashley. Appreciate it. Cassandra, I can see your raised hand. Did you have a question you wanted to put in the Q&A? Tracy, I'm not sure. Can you unmute people to ask the question verbally?
Yes, I can. You said
Perfect.
It's Cassandra?
Yes. And then after her, I believe we have Judge Harmon on the line as well. Oh, Cassandra said no question.
Okay.
So never mind. Oh, and Robin Stevenson came in. She said there are 5 other states that are 90 days. Kansas, Louisiana, South Carolina, South Dakota, and Texas. Thank you so much. Judge Harmon, did you have a question for us as well? I'm going to wait on this. Oh, somebody else wants to know, does anybody know about any updates from the Stevens Group regarding LB 1173? And I think Stephanie is on to answer that question. Let's see.
And if any of our guests do wish to pose a question, you can raise your hand and I will unmute you.
All right, we have another question in the Q&A. It says, has any consideration been given by using anything other than county population, caseloads, et cetera, to determine how many judges are needed? And yes, Claire, there are caseload studies that are done by the judicial branch. I don't know if we have anybody on our panelists who are involved in that, or anybody who is in our watching the seminar who is involved, who can give some more information about that.
Mary Pat, this is Judge White. I'm not on the Judicial Resources Commission, but there is a Judicial Resources Commission that will hold public hearings when a vacancy is declared or being requested currently to decide based on a variety of different factors and evidence whether or not that vacancy should be filled.
Thank you, Judge White. Let's see, are there any other questions outstanding that anybody has that I've missed?
And then Mary Pat, this is Ashley. I apologize. And looking at the chat, I don't know if I answered Stephanie's question correctly. I saw the anonymous surrender, but I didn't see the part about the paternity concerns. Unless someone else knows, I don't believe that there's much language in this bill to address paternity. So I just wanted to clarify that I don't think I answered that correctly, but I just wanted to also see if any of the other panelists, but I don't believe there is much in the current bill regarding paternity, just to answer that question.
Thanks, Ashley. Appreciate that. Joni Watke has her hand raised. Tracy, if she wants to be unmuted.
Mm-hmm. Well, I'm not finding her in the list.
What does it do when I say view? Well, while we're trying to get you unmuted, if you would like to put your question in the Q&A. All right. Actually, it looks. Ooh. Huh.
Oh, here we go.
Okay. Did it
Go
work?
ahead, Johnny. Yes.
Okay. So I was the one that posting anonymously, because I'm chicken, about the surrender and the paternity, because I see not only questions about obviously bio-dad's rights if they want to be involved, but also issues with anybody who's attempting to adopt that kiddo, that we don't have a bio-dad consent. And that bio-dad may have no idea that the surrender even took place.
Yeah, that's a concern. I don't know if we have an answer for that.
I think it's kind of a big one. I mean, not that I don't support, I do support the premise of the surrender, and I get it, but I just think that that's a huge part that doesn't look like it's been.
This is Sarah. I can respond about 1173 because I don't think we did it as well, but also just Joni, I agree with that. I haven't really dug into the safe haven, but we all know the last time our legislature passed a safe haven law, it wasn't, fully thought through the first time. So I think raising those issues now is really important, and would encourage you to share those, and we'll look into them as well. On 1173, I think the question was if there's been any more from the Stevens Group or any bills introduced. I think we were aware that there wouldn't necessarily be any specific bills introduced this session as a result of 1173, but expect that there might be in the future, and really appreciate you bringing that up too, because so much work did go into that, and so many recommendations. And I do hope that serves as a guidepost for the legislature and stakeholders going forward. So I hope we see some steps taken, but I'm not aware of anything this session. But if others are and can speak up, that'd be great.
Thank you, Sarah. Have we missed anybody else who still has a question for the panelists? If you can raise your hand again, we'll see if we can get you unmuted. I'll give you a few seconds. Well, I'm not seeing any. Thank you so much for all the questions. I really appreciate everybody being involved in this and asking our panel questions about all the bills and just the interest in them. And again, thank you so much for our panelists. Once again, that is why I think we see an uptick in our numbers for this webinar, because we have such great experts who give us their time and talent on looking at the bills and picking the ones that, the boots on the ground people really want to know how it's going to affect their life in their cases, in the courtroom, and just in their work. So we really appreciate them giving their time again, twice a year. Remember, we'll be back here at the end of the session to see what passes and, how it will affect the kiddos and families that we are all trying to help. I'm going to give anybody just another minute if they had a question that they still needed answered that maybe we missed, or just a follow-up. Okay, seeing none. Thank you all for being with us, and we will see you. The session ends April 18th. So we will see you at the end of April and see what we're left to talk about. Thank you.